Is bail always granted after an arrest, or can it be refused? Hi, I'm Simon Dippenaar and I'm an attorney. Arrest is a scary business, but the one consolation to anyone in the situation is the hope of bail. Bail is defined as the temporary release of an accused person awaiting trial, sometimes on condition that a sum of money is lodged to guarantee their appearance in court. There may be conditions imposed. For example, the police may retain the passport of someone believed to be a flight risk, but bail is not a universal right. Certain crimes in certain circumstances may cause a judge to deny a bail application. Let me explain. The Criminal Procedure Act allows bail to be refused and the accused detained in custody if the court believes the interests of justice are better served by doing this. Bail can be denied in the following circumstances: where there is a likelihood that the accused will endanger the safety of the public or will commit a Schedule 1 offence. Schedule 1 refers to a serious crime such as murder, sexual assault, arson and the like. Where there is a likelihood that the accused will attempt to evade trial. The court will consider the accused's family and occupational ties, assets and income, and the severity of the crime, among other factors. Where there is a likelihood that the accused will attempt to influence or intimidate witnesses or conceal or destroy evidence. This concern is quite complex, and the courts will consider a number of factors, including the relationship of the accused with witnesses and the extent to which they could be influenced or intimidated, how likely it is that communication between the accused and witnesses can be prohibited, and others. Whether there is a likelihood that the accused will undermine the proper functioning of the criminal justice system is another. In this case, the court will look at whether the accused knowingly supplied false information at the time of arrest or during bail proceedings, whether the accused is in custody or on another charge or on parole, any previous failure to comply with bail conditions, and any other relevant factor. Where in exceptional circumstance there is the likelihood that the release of the accused will disturb the public order or undermine the public peace or security. This is not common, but might apply in the case of a particularly heinous crime, such as the murder of a child. The court will consider, among other things, whether the offence might induce shock or outrage in the community, whether the shock or outrage of the community might lead to public disorder if the accused is released, and whether the safety of the accused might be jeopardized by release. Our justice system is founded on the premise of presumed innocence, which is why we have bail, and that an accused person is not deprived of their freedom until found guilty. So in deciding to grant bail or refuse bail, the court considers the impact of the decision on both the accused and society. The court must weigh the interest of justice against the right of an accused to personal freedom and prejudice the accused will suffer if bail is refused. Furthermore, the likely harm must be weighed against the deprivation of liberty of the accused. This is called proportionality test. My firm, SDLAW, is experienced in bail and criminal defense, including DUI and possession of drugs. We can help with after-hour bail. Save our number, 076 116 0623, but I hope you never need it.